We've been considering the case of a driver who may have had too much alcohol to drink before getting behind the wheel. The police pulled our driver over. And let's say that our hypothetical driver stayed calm and was polite to the officer. The driver probably submitted to the field sobriety tests and did her best. The driver took the preliminary breath test and the police officer got an immediate result. And if the officer thought that there was probable cause, the officer arrested the driver. Then our hypothetical driver exercised her right to remain silent and she invoked her right to an attorney. What advice could a lawyer give the driver now? Drivers arrested for drunk driving don't have to agree to talk to the police. However, whether they realize it or not, drivers have already agreed to take a breathalyzer test. All motorists in Michigan, by virtue of driving on Michigan roads or accepting a Michigan motor vehicle operator's license, have agreed to take a breathalyzer test if they are ever arrested on suspicion of drunk driving. This is the test of important consequence to which I referred in an earlier segment. In Michigan, the police used the data master machine as the breathalyzer test to analyze a driver's alcohol content. Our agreement to submit to testing ahead of time is called informed consent. A good Michigan lawyer can help a driver understand informed consent. There are some very specific procedures that a police officer must follow in order to comply with informed consent law and afford us our due process. A good Michigan lawyer can help a driver understand how the facts in their own particular case may affect the legal outcome. Understand this: if a driver in Michigan refuses to actually take the breathalyzer test, that driver's license will probably be suspended for a year, or maybe longer if the driver had refused the test before within the last 2 years. Furthermore, the driver's refusal can be used against her by the prosecutor to help make the prosecutor's case that the driver was indeed intoxicated. And when the driver refuses the breathalyzer, the police can get a search warrant to draw the driver's blood and to have the blood tested. Therefore, there is little benefit in refusing the breathalyzer test. However, there are some cases where refusing may be wise. I'm not going to discuss those cases now because, frankly, the issues are very sensitive and the discussion is too ripe for misunderstanding in this forum. Seek the counsel of a good Michigan attorney on the topic of refusing the breathalyzer test. Do not resist a blood test when the police have a warrant. Doing that will have a serious legal consequence all its own. Our hypothetical driver should probably submit to the breathalyzer test, even though the results from the data master machine are generally admissible in court to prove guilt. Remember, the law prohibits a motorist from driving with a blood alcohol level above the statutory level. If a reliable test result reveals a high alcohol level, then a motorist can be found guilty, even if there is no evidence that the motorist's abilities were influenced by the alcohol. It seems like the driver has little recourse. Yet, a good Michigan lawyer may be able to help a driver defend herself against the charge. In order for the breathalyzer test results to be used as evidence of guilt, the court will need 3 things. First, proof that the person who operated the data master machine was qualified to operate it. Second, proof that the person who operated the data master machine operated it correctly and followed proper procedure. Third, proof that the data master machine was operating reliably. A good Michigan lawyer may uncover problems with the machine or the procedure that has led the police and now the prosecutor to the wrong conclusion that this driver has an unlawful alcohol content. A driver who submits to a breathalyzer test should carefully follow the instructions of the person administering the test. Failure to follow instructions might be interpreted as a refusal to take the test, even if the driver didn't mean to refuse. A driver taking the breathalyzer test should do 2 things especially. First, breathe deeply many times before taking the test. The machine can register an inaccurately high alcohol result from alcohol in the mouth. Second, blow long and hard into the machine. The machine may not register a gentle blow, and the police may interpret that as a refusal to take the test. Drivers cannot expect do-overs when it comes to breathalyzer tests. A driver should save any paperwork she gets from the police, including the receipt from the data master machine. And if the driver honestly thinks that the data master results are wrong, then the driver can insist that the police take her to the nearest hospital for an independent blood test. If the driver is sure and decides to do this, then the driver should ask for a whole blood test, not the common serum test. A serum test is insufficient. And remember, the driver must pay for such a test. There's no right to a free independent test. I am attorney Roland Lindh, and in previous segments, I've been considering the hypothetical case of a person pulled over for drunk driving. And I've offered hypothetical advice. But if you've been pulled over for drunk driving, you should seek the help of an attorney. Don't let preconceived notions dissuade you from getting the help you need.